well as protect the rights of citizens. So once again, let's hear what Jane James had to say about this development.
We are calling upon all persons that are involved in upholding of human rights that the complainant has a right, the state has a right, and the suspect and the inmate has a right. So we are saying no to every form of delayed justice. We are saying no to delayed legal advice, no to delayed information, no to missing files, no to indiscriminate and unequal charges in court. So we are urging the police commission to charge criminal matters that have death sentence penalty straight to the high court instead of sending it to magistrate court, where we will start waiting for legal advice and the inmates will be there for 5 days, 10 years against their rights.
All right, so this was the basis of a rant that I delivered yesterday, because once again, as I've said, and I did say yesterday, for one, it seems highly illogical to me that a court does not have the jurisdiction to entertain a matter, and yet for whatever reason, the police insist on taking those matters to that particular court, and it always plays out, the scenario always plays out the exact same way. The matter is before the court. Magistrate says, oh, the issue of jurisdiction comes up. We don't have jurisdiction to take on the matter. And then magistrate issues a remand order, take the person to some place, incarcerate the person, and then refers the matter to the DPP for legal advice. Legal advice sometimes takes weeks, takes months. In some cases, even takes 10 years, even takes years, pardon me. And you heard Jane James even reference, she was specific when she said 10 years. I want to imagine that we may have had such an instance before, as utterly ridiculous and improbable as that may sound. But there have been stories that people have ended up staying in prison cells for extremely long periods of time while awaiting the never-ending advice from the DPP. Now, this does raise concerns about human rights violations, and as to whether or not some unwholesome activity may be going on, as to why the police insist on taking these matters before magistrate courts. Now, I've also spoken to lawyers on this in the past, and I'm aware that they also feel the same way. They've also felt the same way in my conversation with lawyers in the past on the matter, that it is not a wholesome practice and the police should desist from it. Now, with all conversation about human rights, making the rounds these days, I thought it wise to, deliver a rant on it yesterday, which I did. And as is the practice, I do get your take on mine. And several persons did call in to express their opinion on the matter. Now, some fellow did call in yesterday as well to express his position on the matter. And that strengthened my resolve to have a further conversation on the issue, even though I was thinking about it already. But it further strengthened that resolve. But we'll get to that in a moment. Joining me in the studio right now on the subject matter, well, there's several talking points here, no doubt about that. But does it constitute a violation of the rights of these accused persons when the police charge cases to magistrate courts, cases that these courts have no jurisdiction over, and all else that usually plays out in those scenarios? Joining me in the studio to help clear the air on this not so contentious issue, actually, in my estimation, is Barrister Festus Oguche. Barrister Oguche, good evening to you. Welcome to Hard Facts.
Good evening, Dio. Thanks for inviting me.
All right, thanks for your time. Before we get right to it, I'd like to play back excerpt from my show yesterday, wherein some fellow, it was an interesting conversation with several persons who called in. A not so interesting conversation is one I'm about to play back right now, where some fellow did call in, and he stated that he's a lawyer, but not a practicing lawyer, and he put forward certain positions, which quite frankly I found somewhat questionable, and I do believe that had a lot to play with the conversation that we're about to have at this time. So here is from the caller on the show yesterday, who insisted, amongst other things, that there is a law that compels or mandates the police to take this or any case that concerns them to magistrate courts. I'm going to play that back now. Hello, Hard Facts, welcome.
Yeah, Mr. Zion, good evening to you.
Go on.
You see, in the criminal justice system, we have 4 stages, and you cannot jump one to the other. If a police make arrest, police station, after that is the magistrate court. That is where the police will find themselves and you the suspects. So no matter how intense that crime may be, they must first attest the waters of the magistrate court. Then the judge over that case will now prefer, this is not my jurisdiction. Take him for legal advice. These are the processes. The only area we can fault, it is the duration, how long it takes for the DPP to schedule this case to the appropriate quarter.
Hello, are you a lawyer?
Well, I'm not a practicing lawyer.
No, are you a lawyer or not? I didn't qualify.
I am a lawyer, but I'm not practicing.
Okay, all right. I have spoken to lawyers on this matter, even on House Fact as well. I believe I've spoken to one or two lawyers on this matter, and I'd rather take their position than yours. I'm quite certain there's nothing in our law that says that they must go to magistrate court first.
Check the legal system properly.
Okay, I will.
If you bring 10 cases to the floor,
yes,
you will find out that they all went to the magistrate court.
No, doesn't make
Are they not educated enough?
Doesn't make it the right thing
for
to
you
do.
No, it might not be to you, but on the legal process, it has 4 stages, which you must prefer them to.
So every case must go to magistrate court first.
As long as the Nigerian police is involved.
No, I'm not asking. No, your response is completely different from what I'm asking you. You are not quoting the practice of the Nigerian police. You are quoting the law, referencing the law.
Legal
so
system.
What I'm asking you is,
the way it is being structured.
Can you listen to my question, please? My question is: are you saying that the Nigerian law states that every matter must be presented before a magistrate court first?
No, not every matter. I use a clause. As long as the Nigerian police is involved.
Okay, once the Nigerian police is involved.
Arrest has been made.
Just a moment, please. Just a moment, please. My question is, are you saying the Nigerian law states that as long as the police is involved, every matter must appear before the magistrate court first?
That is what the law says.
Okay, all right.
For every police arrest, you must take that man to the nearest court, which is the magistrate court. If you are arrested somewhere at LMA Junction, which of the magistrate court along that area that should try that suspect, take him to the magistrate court.
Which law are you referencing?
Hello?
Which law are you referencing?
The law I read.
Which law are you referencing?
I'm referencing to Nigerian law.
Can you be specific as to which law you're referencing?
Specific to you, Nigerian law.
Nigerian law.
Call any lawyer, call any barrister.
Just can you be specific as to what law you're referencing?
I'm referencing to the criminal justice system.
Okay, all right. Okay. Your position is noted. I will ask around. I will ask about that, but his position is quite clear. But I believe I have spoken to a few lawyers on this matter, and their positions differs from his. But I will look into that once again. Now, even if that were... No, I think that was about where the conversation ended. So let's just take it from there. Barrister Festus Oguche, is there any law that states that once the police make an arrest or once the police is involved in any allegation of a crime committed, that the police must first and foremost charge that matter before a magistrate court?
I don't think the gentleman, excuse me, who you conversed with is correct in that direction. I don't think there's any law existing within the body of the laws of the Federation of Nigeria in the subsidiary legislation or rule of practice and procedure that says that the police can only file a charge against an accused person or a suspect in the magistrate court. It's the tradition, the rule of, it's the mode of practice, but it's not a rule. It cannot be elevated to a rule yet. But I think that's part of the orientation of the police and what they have gotten used to. And in spite of some judgments of the Supreme Court and the Court of Appeal, deprecating that particular procedure, they still find it very comfortable to take accused persons, particularly those of them who commit capital offences that will fetch the death sentence, charge them to magistrate courts, knowing very well that those courts do not have the jurisdiction to try those offences. And I think with the evolution of our legal system and the way we have gone, particularly the primacy of human rights at the international level, and it's a lot, the operation of conventions, the African Charter, it has come to a stage that practice has to stop.
Oh, you said that there are rulings of superior courts that deprecate that action.
Yes.
What can you be more specific as to what rulings you're referring to?
Yes, there's the judgment, Ewere against COP. There's also the state against Shagari. But a lot of cases there, a litany of cases, avalanche of cases that says, well, you don't go taking somebody on a holding charge, because that's what they call it. And it's illegal, it's unlawful, it's a violation of fundamental rights. You're giving that person the treatment that degrades his person, because he's supposed to be brought before a court of competence before within a reasonable period of time. And you don't take him to a court that you very well know is incompetent and think you've done a good job. That's the key, and that's the crux of the matter. Take him to a court that lacks the competence, makes him vulnerable to a whole lot of violations, particularly if the court remands him, even without jurisdiction. Because one of the questions the Supreme Court asked in Ewere against COP is, how will the court assume jurisdiction? Or rather, how would a court say, I don't have jurisdiction, but it still goes ahead to remand the person? If you don't have the jurisdiction to try the matter, of course, you don't have the jurisdiction to remand. And there's a row of cases, a row of judicial authorities that support this. But it has somewhat become the practice, and they do all this and get away with it. But I think we've gotten to the stage, like I said earlier, where that practice has to stop. And it's a very good move by these social justice advocates that are raising it at this very critical time. Because if you look at the African Charter itself, Article 7, or even the Covenant on Civil and Political Rights, or even the Covenant on Economic, Social, and Cultural Rights, they are well detailed that it is the right of the person that is suspected to have committed a crime to be taken to a court of competence within a reasonable time. And if you decide on your own, because you are operating a police system that's archaic, to take such person to a court that is incompetent to try the offender, or even to determine the charge, then of course you are violating his fundamental rights. Particularly so if at the end of the day, he's not only heard, but he's also remanded. So what's the implication of that remand vis-a-vis his fundamental rights? That's the question.
No, you've been doing this for a while. I mean, I imagine, practicing the legal profession. Could you explain, and I imagine you're aware how these things do play out when these matters are charged before the magistrate court. Can you explain the process and the legalities in each stage or each step of that process?
Well, the steps are very straightforward, that there's a charge, and maybe the gentleman suspect is being charged on allegations of a crime such as murder. And the police looks at the whole situation, and maybe they feel that maybe some more investigations need to be done. But then within that period of investigation, we have to keep this man in the cooler somewhere, so that maybe he doesn't tamper with evidence, or he doesn't abscond, or he doesn't have cause to commit another crime. In civilized societies, there are better ways of taking care of it. But here, what they do is that they proceed to the magistrate court, knowing fully well that the magistrate does not have the jurisdiction, the competence to try it. And when the charge comes before the magistrate, the charge is read to the accused person, but he will not be given the opportunity of electing whether he's guilty or not guilty. Because, of course, the court lacks the jurisdiction to hear anything regarding that. Then the next stage is for the magistrate or whichever tribunal to order that he be remanded pending the advice of the DPP, either the federal DPP or the state DPP, whichever the nature of the offense, and maybe the people arraigning him. That's just the procedure. But if you look at it from the totality of the proceedings, the totality of the implications of that modus, that's engaged in the arraignment, you discover that from beginning to the top, from the top to the bottom, it's all about illegalities and invalidities.
All right, let's go over the steps again. Let's start with the police. Is it possible that the police do not know or did not know that the magistrate court does not have jurisdiction on these matters or certain matters, and that's why they insist on taking those matters before magistrate courts?
It's not that they do not know. The police have a legal department. A lot of those charges, particularly these days, are formulated by policemen who are lawyers. They have a legal department. They have the OC legal that ought to be a proper position to advise them and to tell them that, look, and they know very, very well, because usually even their prosecutors that are in court always present the matter to the court that there's this charge and there's that charge, but then, at the point of taking the accused person's plea upon arraignment, you discover that the prosecutor will even be the person to say, no, you can't take your plea. So they are fully aware of it. They know very, very well. But like I said, it has somewhat become a tradition in our judicial system, particularly the criminal justice system, that this scenario continues to replay over and over and over and over until people have gotten used to it, and maybe we find ourselves in a very helpless situation where there's a clear-cut violation of fundamental rights, infringement on the right of the person to be fairly heard, infringement on his right to be taken to the court to have his matter heard, the court of competence, and probably to give him the leverage or the opportunity of having his matter defended in line with the constitutional presumption of his innocence.
There have been allegations or insinuations that the police, as you rightly said, or as you said, are aware of the implication of charging this matter before the magistrate court, but sometimes for underhanded reasons, maybe for reasons of wanting to punish the person, or the person is not cooperating in a certain illegal way that they might prefer, maybe offering a bribe or whatever, they decide to take the person to magistrate court, so they will have an order of remand. So it's no longer, especially if the person comes to the lawyer and the lawyer says, you have to release my client after 48 hours if you can't charge him or her to court. Okay, you want to make trouble? We'll take it to a court. The court will order a remand. Go argue with the court.
I think within the first few years of our democratic system, this round of democratic system, that practice was very much rife, particularly in Imo State and parts of Enugu State. I handled a couple of matters in Enugu State. It's not that the person actually committed the offense, but it's just a subterfuge or a leeway to get him out of circulation for the purposes of election. And that's a proper way of doing it. If you meet with the policemen, they just formulate the charge. It could be any charge whatsoever, so long as it is tied to an offense that is capital in nature, or the one that will attract a capital punishment. And once the court sees it, that's the end. He gets remanded, and he remains there until the election is over. A particular young man spent about 5 years in the prisons at Enugu. He was just released some 2 years ago by the Federal High Court. And on trumped-up charges and charges that have little or no proof. And that is why the recommendation of Professor Fagbohun has been very, very on ground, that, look, charge them to the courts that have competence, because if you are taking them to the High Court, there must be proof of evidence.
Talking about that, can the police charge these matters to the High Court rather than the magistrate court?
They can.
So why don't they go to the High Court? Why magistrate court?
That's a question that should be answered by the police. Because we have gotten to a stage, thanks for the advocacy of these gentlemen you talked about, we have gotten to a stage where we now begin to say, no, this cannot be. We must align ourselves with the civilized world in terms of fundamental rights provisions. After all, it's not just by virtue of our constitution alone, it's by virtue of certain global norms acceptable, by the Committee of Nations, that these are the standards for preservation of fundamental rights in domestic entities. So we cannot do it our own way and get away with it. It is not done anywhere. No. I think this practice is being abrogated in most third world countries, especially in African countries. And I'm just surprised that in spite of all the pronouncements of the Supreme Court and the Court of Appeal, deprecating that practice, it's still being used.
The second stage here is the magistrates themselves.
Yes.
A magistrate.
They're remanding magistrates.
The magistrates, yeah, exactly. So the matters before you, magistrate, you know that you have no jurisdiction to entertain this matter. So, can we assume then that the magistrates themselves do not know the proper thing to do, and that's why they go ahead to issue this remand orders?
Well, I will say that they are responding to charges brought before them, and they are reacting to a given set of traditional circumstances. Though there has been a little innovation on their part, most recently, where they now peg it that this suspect, this accused person, is remanded in prison custody pending DPP advice, and they are adjourned to a particular date, and on that date, if there's no DPP advice, they could let them go. That's quite innovative, and it's just a new thing that has come in now. But over the years, a magistrate, you are sitting as a magistrate, and a matter of this nature regarding crime, regarding a very weighty crime like murder, armed robbery, kidnapping is brought before you. Will you have the energy, the audacity to set the person free by granting him bail? You cannot even assume jurisdiction in it in the first place. And
why entertain the matter at all?
You would expect the kind of intellectual creativity that you're advocating to be the forte of the average magistrate who's standing in that particular chair, in that hot seat at that material moment. Will he now decline that he will not entertain the charge before him? He'll get he'll get questions from his superiors. Okay, what will he do in the circumstance? There's nothing he can do. Or will he now tell the police, well, I can't take this particular charge, I don't have the jurisdiction?
But he doesn't have jurisdiction.
He doesn't have jurisdiction, but then what about the accused person who could be a very dangerous person? So a lot of these things come to play. That's why we are talking about wholesome reforms from the Supreme Court down to the lowest courts.
Can't he order the police to take the suspect back and charge the person to the appropriate court?
Well, he can. That's another angle to it. But how many of them have tried that practice? Because if they now begin to decline the acceptance of such charges before them, then of course the practice will change. It will alter the course of the practice. But at the end of the day, I think the average magistrate is looking towards a situation where justice will be served, in terms of the complainant vis-a-vis the accused person, and to ensure that maybe the efforts of the police to curb criminality in our society is not frustrated or truncated.
But in remanding the person of whom you have no jurisdiction to hear their matter, injustice is served, actually.
Yes, it is.
Now, let's go to the third part of it. That's the DPP. When the magistrate requests advice from the DPP, what exactly is the magistrate asking? Because can the DPP change jurisdiction and determine that, magistrate, suddenly we've realized that you have jurisdiction on this matter and you can hear it. So what is the nature of advice that the magistrate is seeking from the DPP really? And does the DPP not know that the magistrate has no jurisdiction in that matter?
It's not the magistrate seeking the DPP's advice. It's the DPP's advice for the purposes of the prosecution of the accused person in the appropriate courts. I hope you get that distinction. But what is important is that the DPP advice is very necessary at that point to ascertain whether it's a chargeable offense, whether it is one that can be tried by the DPP, whether the offense has been established by the evidence that the police will submit as part of that advice. And that's why I consider it as quite a cumbersome procedure, because all the police need to have done is to do their investigation thoroughly and take the accused person who had committed a very heinous, a very heavy offense to the appropriate court with a proof of evidence. But they say that probably at that time, particularly if it's an accused person who was not arrested at the scene of crime or seen committing that crime, there will be need for more further investigations. But that's no justification for the practice anyway, as far as I'm concerned, because I think we are supposed to have advanced beyond this stage, and particularly so in a situation where people take advantage of these loopholes to look for ways to victimize persons or visit vendetta or their enemies through that procedure. But I think with this newfound advocacy, a lot of people will now key into it to ensure that we have a proper modus, a proper mood, or a proper manner of getting accused person who commits very, very serious offenses, capital offenses, arraigned, and ensure that in doing that, their fundamental rights are not abridged or are not suspended in any manner whatsoever, either by courts or by the police.
It is Hard Factor 91.3 Nigeria Info here in Port Harcourt. We go for a quick break. We'll return in a moment. This conversation will continue. Please stay with us.
Information is a two-way thing. Nigeria Info, it's your turn. Let's talk.
And now, Hard Facts. Hard Facts with Adeayo.
Welcome back to the Hard Factor 90.3 Nigeria Info and here in Port Harcourt. I'm Adeayo. 19 to go before 5 o'clock. Still discussing Human Rights Group Legal Care Advocacy Foundation urging the police and other relevant security agencies to stop taking criminal matters that have death sentences as penalties to magistrate courts because they have no jurisdiction over these and several other matters as well. And chairperson of the group, James, made the call to mark International Human Rights Day. And as I did mention, an alleged non-practicing lawyer also called the show yesterday to make certain suggestions or postulations that there is a law mandating the police to take every matter to the magistrate courts before proceeding to any other courts. Of course, I sensed that something was wrong with that position. But my guest in the studio, Barrister Festus Oguche, very well primed, of course, and experienced to answer these questions. He's joined me for this conversation. Barrister Oguche, you're welcome once again.
Thank you very much.
Remember to join the conversation as well via facebook.com/Nigeria InfoPH. We are live there. WhatsApp on 0809-030-6416. You can also watch on YouTube. Just search for our YouTube page, Nigeria InfoPH. We'll go to the phone lines in a moment. Barrister Oguche, also still with the DPP, who has been asked to proffer legal advice here. You explained the DPP's role a while ago, but the DPP, in my estimation, is also aware that the magistrate has no jurisdiction to entertain this matter. Why then is the DPP giving any advice to the magistrate court when the magistrate court does not have the jurisdiction to entertain that matter? Also, even these advice that's supposed to come to the magistrate courts, we get reports, so it takes weeks, months, and sometimes even years with the suspects, guilty or not, and in many instances they're not guilty, languishing in incarceration because a court that has no jurisdiction has ordered that they be remanded, while the DPP, we hear sometimes they're looking for case files, papers go missing, this one goes missing, all kinds of things go missing, and they're unable to offer that advice.
Well, that's a double-pronged question you've thrown there. First of all, I'd like to say that that practice is a part of the vestige of our military and colonial past that we have been unable to shake off our system. The DPP's advice is not to the magistrate; it is to the charge itself, the validity of the charge, the proof of evidence, the proper court to assume jurisdiction on, and because at that point, after the magistrate had given the order remanding the accused person in prison custody, I guess at that point he had nothing else to do because he doesn't have jurisdiction. So the advice is upon the charge, and I think it's rather a very curious procedure to adopt, in the sense that in our adversarial system of law, the DPP has no role to play in determining who is guilty and who is not guilty at that stage. But then we have a system where, through that mechanism, the DPP is to determine whether the person is guilty or not, because by the power of his advice, he can exculpate a dangerous criminal at that point without compunction whatsoever. And that is a very dangerous trend, and that's why we are saying there should be reforms. Within that also, he can also inculpate somebody who is a friend of the government, of which is the DPP, and that is why you always find it difficult to get people who commit electoral offenses, particularly in states where they are supportive of the government in power. Where you get them remanded, and even in situations where they get charged to court, the DPP advice could come in minutes or even in seconds. But then we have situations also, like you said, where DPP advice will not be forthcoming for as much as 5, 6, 7, 8, 9, 10 years. And people are there languishing in prison custody. And that is why it is very, very important that we have a proper review of our criminal justice system and see how we can remove some of these, what I may call clogs in the wheel of justice, because you cannot be dispensing justice within the ambit of injustice, within the annals of injustice. You know, you cannot use an illegitimate means to attain a legitimate purpose. The role of the DPP should be very much clearly defined, and that is when somebody is charged appropriately on a charge before the usual court that has jurisdiction, for him to come, get all the facts and all the evidence from the police, from the investigating authorities, and go ahead with his power of prosecution in the manner he deems fit and with professional zest and savvy. But not to sit there and maybe somebody is charged to court and it happens to be somebody you're closely related with one way or the other, either as friends or as a kinsman or a party faithful and all that, and you just sit there and your one single advice you give will just give him that freedom that he doesn't deserve anyway.
Join the conversation right now. If you would, the lines are open. Call 0817 93 0002, 0817 93 0003, and 0817 93 0007. Keep it brief and straight to the point as well. And remember to turn down the volume of your radio set once the call is answered. On WhatsApp on 0809 030 6416. Also via facebook.com/Nigeria Info page as well. Let's get your take on this matter.
And if I may add also,
I
think we should also note, in spite of the fact that I said that the DPP advice has to do with the charge. So in most cases, the advice does not pertain to the charge itself, because there are circumstances where the advice of the DPP is not in consonance with the proof of evidence that turns up at the end of the day, in most circumstances.
All right, let's see what's happening via WhatsApp. Oh, we'll come back to that in a moment. Hello, hard fact to welcome.
Hello.
Hi, go ahead, please.
Good evening.
Hi, go ahead.
Okay, I want to ask. My name is Chris. I want to ask. So, what does maybe the accused person happen to have a lawyer? What does the lawyer do when he found out that the police is now wanting to take the matter to a court? A magistrate court that's not competent jurisdiction. What should the lawyer do to alter that so they don't go ahead with that process, which is illegal?
That's a good question. And there are instances that we find ourselves in such awkward position, and what the lawyer will do is just probably to rush to court and to buoy up the confidence and comfort of his client, so he doesn't feel deserted or dejected completely, and just sit in court and be moping, because there's little or nothing he can do. He cannot move any application for the bail of his clients, because his client has not been arraigned properly, so-called, in the manner of his plea being taken, whether guilty or not guilty. It is after that that you can move an application for bail. So he has no other rule than to come sit in court if he wants to do that. I don't do that these days, but or just sit somewhere by the corner and watch his client being thrown into the Black Maria towards all the way straight to prison and in custody. And maybe probably the next day he could bring application before the High Court for bail, and because it is the High Court that has the appropriate jurisdiction and competence to grant bail to such offenders, within the ramification of such offenses, and those ones that attracts capital punishment. So it's a very serious situation, very sorry state for the lawyer who is representing his client, because he'll find himself in totally helpless situation.
All right, over to WhatsApp right now. Good afternoon. I believe it can be nipped if lawyers' association in each state have a petition line where such judges with such repeated behaviors are sanctioned or suspended or discouraged. To discourage such as it is obvious that they are in bed with the police in this ordeal. We will set that in. Hello, hard fact to welcome.
Hello, good evening.
All right, go ahead.
Yeah, my name is Roman. I'm calling from Meshaland.
Go ahead.
Okay, I have a question for the guest in the studio.
Go ahead, please. Go ahead.
Should I narrate my situation? I had a conflict with men from the Uzoba police station, and in less than 1 hour, I was arraigned in the customary court at Toba. So I don't know if the customary court has the jurisdiction to handle traffic offenses, because my offense was traffic related.
Okay.
Hello?
Well, I think if you're seeking for legal advice, you should go consult a lawyer, pay the relevant consultation fees. I don't think it's within the ambit of our discussion. But for all I know, you have to look at the laws of the laws establishing the customary courts and know their area of jurisdiction in terms of competence. Whether they can try traffic offences is something that I'm not yet sure. I have to look at them. The customary courts in River State are not within my area of practice at all. Though I could have one or two reasons to go there sometimes.
All right, like I said yesterday, the bench and the police are in cahoots to accept cases outside their jurisdictions and then remand the accused as if they don't know the right thing to do. Why don't lawyers like the one in the studio file charges against the bench or petition the judiciary? Otherwise, let all parties prove their innocence. I was going to come to this because a message I read a while ago also echoed this as to we have the Nigeria Bar Association, we have the NJC as well. Why can't something be done, or why hasn't something been done? You mentioned several orders or rulings or superior courts, but something, well, obviously that hasn't been cogent enough because the practice has not changed. Why hasn't something more cogent, something that would definitely change this practice, happened thus far?
That's why we are calling for reforms. And by the way, you don't hold magistrates or judicial officers responsible for the practice, as in maybe getting a magistrate to remand somebody without jurisdiction responsible for such action, or maybe having the notion that is something that should attract some form of disciplinary action against him. No, it's a tradition that we have gotten involved in, and it's something that's been there for quite some time. So it's taking time for people to change, and we are yet to be used to. It's not just the judicial system; in every system, we are yet to be used to radical reforms, as reforms that are attuned with the dynamism of society. We ought to have advanced beyond this stage like every other country. I guess in the 70s, that practice obtained in most countries, but I can bet you that if you go to those countries, they do not obtain anymore. It's our reluctance, simply our reluctance to adjust to the dynamism of society and to try to elevate the human condition from one that can be suppressed to one that can be elevated. And to the extent that I understand, it is something that needs really to be abrogated in view of the pronouncements of those the Supreme Court in Were against State against Shagari, and then condemning, deprecating that procedure, that it is illegal for a magistrate to sit and remand somebody within the ambit of a charge of which he lacks competence. That if you take the accused person to the appropriate court. And there's been some bit of studies and findings, particularly I mentioned Professor Fadbohun, who made very strong recommendations that, look, the proper thing to do if you arrest a person and you're yet to have sufficient evidence against him, whatever, you can make the bail conditions stringent, so you can formulate other measures. But what is important is that if somebody is arrested for a particular crime, you take him to the court that has the competence to try him. If you do anything contrary to it, you are breaching the international obligations of Nigeria. You are violating the provisions of the Constitution of the Federal Republic of Nigeria, 1999.
And I have a question here. Why arrest a person when you have no evidence to charge the person with? What would have been the point of making that arrest? No,
in the course of investigation, suspicions are allowed. You could look at somebody's face and maybe don't like it. And I think the proper thing to do is just to get him on, or maybe have some bit of private squabble with somebody and he runs into your path in your course of parading, doing your investigative
but that's
duties
not the reason
as a police officer.
But that's not the reason.
There could be other parochial reasons for these things happening. But the general notion is that, one can be suspected for committing crime, that maybe a bomb blows up somewhere around this neighborhood and see people running around. You may not necessarily see somebody with the live bomb in his hands, but of course you're suggesting
we must wrap this up right now. Okay. Thanks for listening. Thanks to my guest, Barrister Festus Oguche. Always a pleasure to have you here.
Thank you very much. My pleasure.
Commercial break right now. News update up on the hour at 5 o'clock. We continue to other matters. The Commissioner for Health in Rivers State, Professor Chike has been sacked by the governor. I'd like to get your take on what happened. Just stick around.